Good afternoon and welcome to the Committee of Adjustment hearings for Suburban Panel 2. We're a City of Ottawa quasi-judicial tribunal that holds public hearings to consider Planning Act applications, including minor variances to the zoning requirements and consent to sever. Our hearings are now in person at Ben Franklin Place, 101 Centerpoint Drive. We also enable remote participation by video conferencing for our registered speakers. We are live streaming on YouTube, and the video will be archived and available for future viewing by the public. My name is Fabien Poulin. I'll be chairing today's hearings, and you can address me by my name or as chair. And with me are my fellow panel members, Jay Baltz, George Barrett, and Heather McLean. The procedure for the hearings will be as follows. Listed on the agenda and appearing on the screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with agenda items in a different order. Panel members have reviewed the planning reports and any written submissions in support or opposition to each of the applications. Today, we'll hear any oral submissions relating to the applications. As part of the statutory public notification requirements, each applicant was required to post a sign on the property in question before the hearing. They also had to confirm in writing that they did so, or they'll need to swear or affirm an oath today that they've fulfilled the sign posting requirements. Otherwise, we may have to adjourn or postpone the hearing. The panel may ask for a brief presentation of the application, followed by questions for the applicant and city planning staff. We will then hear from members of the public who have registered to speak, and we may also have questions for them. Finally, the applicant, who has the burden of proof, will have the opportunity to make final comments and reply. Please address your comments to me as the chair, starting with your name and spelling it if necessary, and your municipal address for the record. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel may either make an oral decision or we may reserve our decision, which means it won't be delivered today. In either case, and within 10 days, the Committee of Adjustment will send the official written decision and reasons for it to all parties and participants and everyone else or anyone else who has requested a copy. Does anyone have any questions about the procedures we'll be following today? No questions? We have several applications to hear, but first we'll need to deal with some preliminary and procedural matters. Are there any declarations of interest by panel members? No. There are no declarations of interest. Need to confirm the minutes of the last of October 3rd and October 17th. First of all, I'd like to ask for approval of the minutes of October 3rd. All those in favor, please raise your hands. Those minutes are approved, and we'll also like to ask for approval of the minutes of October 17. I will have to abstain. I was not present. All those in favor? Those minutes are also approved. We have several adjournment requests that we need to address today. The first of which is having to do with application number 3. And today I'd like to ask our planning department if they could come online, if they're online, or if they're here. Great. Planning here. Where is that? So I'm dealing with application number 3 having to do with 44 Dunham Street. And I'm looking for Cass Sclerosero. Are you available, Cass Sclerosero? Good afternoon.
Good afternoon.
I believe panel member Baltz is looking for some information on this application.
Yes, thank you, Mr. Chair. So the zoning, which is R1WW for this, has an exception, if I'm correct, of 637. And so that exception, I think, is that the minimum lot area would be 555 meters squared. Is that correct?
That's correct.
So the variances, however, are asking to be varied from 450 meters squared each, which is the underlying zoning. Should that not be 555 for each of the 2 minor variances?
I'll have to take a look back at the notice. Just give me a moment here. So I did note no concerns with the request, but I'll take a look at the notice just to confirm. Sorry, it's just taking me a minute to get into the my own folder for the file.
I could interrupt. Could we get the applicant or agent to come forward, either online or in the room?
So we'd be looking for Paulo Alves.
Thank you. I was
He's
just
here.
about to ask you through Mr. Chair that we do that.
So, okay, so I do have the notice up, and you're correct that the underlying zone, it does require 550 square meters. And so, and yeah, the notice does say 450 square meters. So that's a good catch. I did miss that in my review. I'd had a pre-consultation on this application a while ago, and I was aware of the requirement for 550 square meters, but I noted no concerns from that, and I provided rationale, but I guess I'll have to defer to the committee staff to determine whether an adjournment is actually required, because the notice is incorrect and more relief is actually required than what was published.
Okay. You have any comments, Mr. Alves?
Yeah, we spoke about this during the planning stage, and as far as I understand, this was an old City of Gloucester exemption, as explained to me. So this is news to me at this point. So I just want to make sure that we're on the same page here, as not sure why the exemption is carried to the new zoning bylaw with the City of Ottawa.
Mr. Walsh, any further?
I did check, and it is part of the new zoning bylaw. And since this is now a larger variance, I think, Mr. Chair, that this would need to be recirculated and adjourned sine die.
Exactly. It does need to be recirculated, Mr. Alves,
Okay.
with the new information so that the public is fully aware of the extent of the variance requested, because the one that was on this existing notice is shy. You're asking for a greater variance.
Understood.
Okay. So to that end, I'd like to ask the panel for approval to adjourn this application sine die for it to be recirculated, and we'll hear it in due course as it moves forward. All those in favor of adjourning this application sine die? The application is adjourned. Thank you, Mr. Alves. Yeah, I will just, we'll explain to you what had just happened. So the notice went out and there was an error in the notice. The notice requested a variance of 450 meters squared, when in fact, the requirement is for 550 meters squared. So it has to be recirculated and then will reappear here at a later date once it's all the timelines have been met. Okay, so I'm sorry you had to come all the way down here for that. Well, we caught that just about an hour ago. Okay.
Just confirm the address for Tom.
Sure. So the address we're speaking about is 44 Dunham.
Sort of way to speak this the current spot. It's way that.
Well, that's okay.
I still need to.
No, Maureen, yeah, we're going to save that for another time, because right now we're just dealing with the adjournment. So the adjournment is requiring that this this application be recirculated. So the notification will go out to all parties near the location. And so it'll be recirculated with the new variance requested, because the information that was requested or the variance requested was erroneous.
Oh, I see. Thank you.
Okay.
Yeah, so then I'm able to speak at another time.
Yes, ma'am.
Thank you. I appreciate that.
You're welcome.
Take care.
Thanks, Evan. Okay, now we'll move on to applications 6 and 7. 6 and 7, and these have to do with 820 and 814 High Street. And the agent, William Ritzy, are you available? Come on down.
Mr. Same planning staff person?
Is it the same planning staff person?
No.
So Samantha Gachin is the planner?
Excuse me, can I just ask a question on that previous
Sure.
item? Who's responsible for payment of the recirculation?
The applicant.
Applicant, okay.
Okay, again, Mr. Balch, you have some comments that you'd like to make or questions you have for Ms. Gachin?
Yeah, seems to be my week. So I have a few questions. One's pretty minor. I think it's an 820 High Street, actually on both of them. The third variance says that it's 30%. This is the reduced rear yard setback one. And it says that the required one is 30% of, I believe, 38.57 in depth, but 0.3 times 38.57 is actually 11.6 if it's rounded. So that's small and we would have to change it here. But that I'm flagging that. The main one though is, yeah, there are only two. The both of the variances E, which were the ones that had rear yard landscaping, were struck out because the wording applied to R4U zones, which I agree. This is an R4N zone. And in the R4 section of the zoning bylaw, in section 168.8, I believe there's a 30% of lot area open landscaping requirement for stacked dwellings required by that provision. Am I incorrect?
Ms. Gachin?
No, it's
So
yeah.
so Mr. Chair, so my understanding, so why that was struck out, so it's stacked dwellings within the R4U subzones, R4A to R4D. That's why. So even though it's a stacked dwelling, it has to be within one of those zones. That's my understanding of the zoning bylaw, what it says. So it's not just for stacked dwellings in those specific zones.
Unless I read it incorrectly through you, Mr. Chair, the section is, there's a separate section for R4U zones, which are new, which have a whole series of detailed provisions. And that doesn't apply here. Those are the ones that were struck out. There's a separate section, 161, and under 161, number 8, which talks to all the R4 zones in general, excluding R4U. And since this is R4N, I believe that applies, and it requires 30% landscaping, 30% of the total lot be landscaped. And so if I am correct, then that would be needed to be variances here, because I don't believe that there's 30% landscaping being provided.
No, we actually showed 12% from what we thought was the 15% requirement. And it was explained by the planner that that's an ongoing change to the bylaw that hasn't been formally approved as yet in terms of the various landscape requirements for multiple dwellings.
Right. I'm only looking at the current one.
Yeah.
So yeah, the planner will have to answer that through Mr. Chair.
Yeah, just waiting for her to.
So just confirm. So I'm looking, I have the provisions up right now. So you're saying 161E is where it's for the R4U zones, and then could you just repeat which section is for stacked dwellings specifically that you're referring to?
So because we have these city computers, I don't have the zoning bylaw in front of me anymore. But what I wrote down was section 161, and it was number 8 under 161.
Okay, so number 8. Okay, so what I have here up, I can also share my screen if that's helpful. I don't know if that's helpful. I don't know if we usually do that on the virtual. I can show it would that help?
You can do that here. Yes, please.
Okay. Take that. Just a moment. Okay, so it's host disabled participant screen sharing. So perhaps. committee. Could the coordinator enable it so I can
Yep,
screen
they're
share?
working on that right now. Ms. Kachina.
Okay. Thank you. Okay.
Good to go now? Go ahead, give it a try now.
Great. Thank you. Okay. Excellent. Okay. So can the committee see my screen now?
Yes.
Okay, so I believe this is the section that Member Bolts was referring to. So number 8, except where less than 450 square meters in the R4U A to R4D zones, 30% must contain the landscape area for the, including stacked dwelling.
Right.
So I think we just,
So I'm correct that that applies in this case.
no, it does not, except for the left, okay. Oh, okay, I think, okay, so I
Except
apologize,
for
I
the
misread
R4
it.
units.
It's that, oh, understood, yeah, so you're correct, it says, okay, so it's accepting those zones from
Yeah.
R4 UA to R4G, so yes, in that case, it would apply then to this.
So again,
I apologize for not catching that.
yeah, so again, we have a much more restrictive zoning that hasn't been, a variance hasn't been applied for.
Right.
So I think we're looking at an adjournment
And a recirculation.
or to be dealt with staff.
So there would have to be a recirculation, sir, because the variance is exceeding the one that you've requested and the public were not notified. So the recirculation was required in this instance, and we would need to adjourn this application sine die until that work has been completed. So I'd like to ask panel for approval of adjourning this application sine die and for the recirculation of the application. All those in favor? The application's adjourned.
Could I, so the actual circulation is just referring to that one. So we'd be recirculate based on that one
Variance.
item.
Yes.
Everything else would be okay, approved.
No, that's not the case. We haven't heard the application yet. It's a good try though.
Oh, you gotta try these things. You know. All right.
Also, through you, Mr. Chair, you might want to correct that minor math error in the 30%.
Yeah, we took the midpoint of the lot, so that's.
No, it's just, it was a multiplication. It should be 11.6 instead of 11.5. So if you're recirculating anyway.
So we'll make the 0.1 change. Okay.
Yeah.
Okay, thank you. Now on to the last two applications that are up for adjournment, and we've been notified, or is Ken Gibson here? This has to do with 136 Acacia and 138 Acacia. Madam Coordinator, as the agent agreed not to show up and has agreed to the
That's correct. He has agreed to the adjournment and is not appearing today.
okay, so this application will be adjourned to December the 12th. All those in favor, please raise your hands. So this application 8 and 9 for 136 and 138 Acacia will be adjourned to December the 12th. Thank you. Okay, so now we have two unopposed applications. The first one is application number 4, having to do with 2705, 2707 Moncton. So we note that this item, there's no opposition by any of the agencies, city, no opposition from the public. So I'd like to ask the panel for approval of these applications, 2705 and 2701 Moncton. All those in favor, please raise your hands. The application has been approved. Thank you. Next on the list is 1819 Arizona. Nathan Eckert is the agent. And again, I'd like to bring to the attention of the panel that this application is unopposed by any of the agencies and any of the public. So to that end, I'd like to ask the panel for approval of this application.
Mr. Chair, just a point, I think we had to revise it a little because it didn't include the exception 623 in the description of the zoning.
That's true. That's correct. So
we should correct that and then.
We'll amend the zoning so that it reads now R10 with the exception 623. But again, no opposition has been recorded. And I'd like to ask the panel for approval of this application. All those in favor? So this application is approved as well. Okay, now moving on to the Orders of the day. First application we'll hear is having to do with 2691 Violet. Harlan Tanner is the agent. Are you available? There you are.
Good afternoon, Mr. Chair. Good afternoon, committee members.
Good afternoon. And I'd like to ask you to give us a brief description of your application, sir.
Absolutely. So it's what we would typically call infill semis. So a house was torn down and 2 semi-detached units are being built in place. There was a variance application which was dealt with previously, and now we are just dealing with the consent application for the severance of the property.
Thank you. Any questions from the panel, Mr. Barrett? Any questions from the panel? Ms. McLean? Mr. Bolts? No questions? Okay, thank you. I'd like to ask Planning Department if they have any comments to make. Shahir Jalal, are you available?
Hi, yes, Mr. Chair, I am.
Hi there.
Hi, planning has no comments.
No comments, no questions, no concerns?
Nope.
Okay. Does the panel have any comments or questions for the Planning Department? Mr. Baltz? Okay. Mr. Barrett? No. Ms. McLean? Okay. So no comments from them. And we have some concerns from the public, I believe. And I think the Ms. Pierrette Benoit, are you available? I believe you're online. Good morning, afternoon. Ms. Benoit?
Yes.
Hi. Could you just state your name and your address, please?
Pierrette Benoit, 2706 Violet Street.
Okay, please go ahead and if you want to make your presentation.
Thank you. I'm concerned about the current impact of this address, the impact that it's having on the residents of Violet Street. And I'm questioning why this particular change at this point in time. Initially, we, the residents, were received a letter from an architectural firm saying that they would be building 2 units on the site to accommodate a young family who would own 1 unit and rent the other. After close to 2 years of construction, and some of us did some research, we found that the 2 units would actually be rented through Airbnb. So no longer considered, in my view, residential, but more a business or commercial. Now, Violet Street is a very short street. It's only 1 block. It has no sidewalks. And so the arrival of these 2 Airbnbs, which each accommodate, it says, has 3 beds, so at a minimum 6 people, has really increased the traffic, and the parking has become a serious issue on our street. Each unit has a laneway that only accommodates 2 vehicles, and there have been times where there's been as many as 15 vehicles for when the 2 units have been rented through Airbnb. They're parking on both sides of the street when there are clearly marked signs from the City of Ottawa that says that parking is only allowed on the north side of the street. At one point, there was even a huge camper parked on the north side, facing in the wrong direction, with vehicles also parked on the south side. This means that on our street, we now cannot have 2-way traffic. It's just 1 car going in either direction at a time. And it would be virtually impossible for emergency services, particularly the fire department, to be on our street. So that is a serious concern. And also, because there are no sidewalks and it's a short street, and we also have small children, families with small children on our street, it's really, I think, a safety issue for the children on the street. And finally, and I'm not sure how this fits into this, but with the City of Ottawa facing such a challenge in having homes for people, and the desperate need to create more housing for individuals, I fail to understand why this particular new build is allowed to operate as a business, as an Airbnb on our street. And so that is what I would like to say. Those are my concerns and the reasons for my concerns.
Thank you very much, ma'am. I'd like to ask panel if you've got some questions for Ms. Benoit, Mr. Baltz.
Yes, I can. I'm not sure it's a question so much as a comment, but so it was permitted up till 2 years ago, I think, to operate standalone Airbnbs, but that's no longer true in the city of Ottawa. So you're correct. The loss of housing wasn't seen as an issue, and it was prohibited. So other than units within someone's principal residence, it's no longer permitted to operate as an Airbnb. And that would, but we here can't deal with that for a severance. That's not one of the issues that we can look at, but that would be something to address with your counselor or through reporting to the city at 311. But we can also ask if that's the current use. Yes, through you, Mr. Chair. Sure. Can you confirm whether this is being used still as an Airbnb or not?
Unfortunately, I don't have any knowledge of it being used as an Airbnb, and I am not to contradict, but I'm not aware of that. It was never raised with me, but I would concur. I mean, if it's being improperly used, then it's a bylaw issue. I don't know what else I can say about that, along with the parking situation. If people are illegally parking, then that's something that has to be taken up with the city.
So through you, Mr. Chair, Ms. Benoit, I would suggest calling 311 or talking to your counselor's office, so if there are bylaw concerns like that.
Okay, thank you.
Ms. McLean, any questions? No. Mr. Barrett, any questions?
Just a comment or with regards to the parking on your street, again, another bylaw issue which could be handled by a call to 311. Thank you.
Thank you, Mr. Barrett. I'd like now to ask the applicant if you've got anything else you'd like to make comment on.
I do not. That's the.
Okay. Thank you very much. I think what we'd like to do is reserve this judgment today or this application for further discussion afterwards. You will receive our decision within 10 days. It'll be a written decision. Thank you very much, sir.
Thank you.
Moving on to application number 2, having to do with 2199 Boyer. I'm looking for Christine McQuaig. And I believe remote. Are you remote, ma'am?
I am remote today, yes.
Okay. I think we have a little bit of administrative details to resolve. I think the size of parts 1, 2, and 5 should be 165 meters squared.
That is correct.
And parts 3 and 4, the rear unit should be 291 meters squared. Is that correct?
That is correct.
Perfect. Can you please give us a brief description of your application today?
Yes, Chair. The description of the application today is to seek approval for a consent to sever for a long semi-detached at 2199 Boyer Road. If you can progress to the next slide. I expect you want me to keep my presentation brief.
5 minutes, ma'am.
Thank you. 2199 Boyer is located on the east side of Boyer, north of Innes Road and south of Orleans Boulevard. It is located in close proximity to both transit as well as several amenities along Innes Road. Next slide, please. This is the location of the subject site. As you can see, the various lot sizes around the site do vary in size and shape. Next slide, please. This is the existing survey of the subject property. Next slide, please. This is an image of the subject site at present. As you can see, there is a hydro pole out front, but per the site plan that we have reviewed, The hydro pole will not need to be relocated for the subject development. Next slide, please. These are some other images just demonstrating the existing circumstances of the street. At the top left is directly across the street. There is a proposed semi in the vacant space between the 2-story brick and the single-story brick in that top left image. The top right image shows the dwelling immediate to the north of the subject site. And then the bottom left image is of the townhouse development that is part of a planned unit development to the sort of southeast of the subject property. And then at the bottom right of your page, you will see sort of looking towards Innes Road from the subject site on Boyer Road. Next slide, please. And this is an example of one of the sort of only multi-unit buildings in the neighborhood at present. It is primarily single detached in this neighborhood at this time, with slowly transitioning, such as the one across the street, which will have a proposed semi with additional dwelling units as well. Next slide, please. The subject site is designated neighborhood within the suburban transect. It is also part of the evolving overlay due to its proximity to Innes Road. And the site is zoned residential second density subzone N, which does permit the proposed long semi-detached dwelling. Next slide, please. So the request today is to request a consent to sever the long semi. As I'm sure you're all aware, long semi-detached are considered one lot for zoning purposes with regards to lot width and total area. And so we comply in both of those situations. As the zoning provisions that permit 3 units as of lot per Bill 23 have recently been approved, it is the intent that the second floor would have additional dwelling units as well. So there would be 2 primary in each, 1 primary in each, and then 2 additional dwelling units for the long semi. And there will be some shared access for the additional dwelling units. And a joint use and maintenance agreement is also going to be put in place to address those shared common areas, both exterior and interior. And it will add rental options to the neighborhood, which currently there is a notable lack of. Next slide, please. This is the proposed site plan. 2 parking spaces are provided with the balance in soft landscaping, 2 new trees, and some bicycle parking spaces to address the multimodal desires for the subject site development. As you can see, part 5 in green, this will be where there is a shared common access for the additional dwelling units only. And that will be owned by the front unit with permissions for access provided to the rear unit. We have consulted with legal from our side as well as the city, and all of it is sort of in line and legally permitted and can be addressed through a joint use and maintenance agreement. Next slide, please. The table hasn't been updated, but as per the beginning of our discussions, we did update the respective lot areas that would apply to the front unit and the rear unit. And then the bottom right image just depicts that part 5 component that will be a shared access space to provide access for the additional dwelling units. This was simply to save on building efficiency so that we didn't have to have 2 separate internal staircases, and we wanted to minimize the amount of built form on the property. Next slide, please. I will just conclude at this point, noting I only have 4 seconds left, to note that the use is permitted. All zoning setbacks and other performance standards have been adhered to. There are no minor variances requested. And this project is in line with the overall provincial and municipal direction to promote and encourage more multi-unit rentals in areas that typically don't have variety of use, residential use such as this. Thank you, and I am available to answer any questions.
Great. Now, are you aware of the conditions should this application be approved today?
Yes, I am aware of the conditions, and we have no objection to the conditions being requested.
Super. Thank you very much. Now I'd like to ask the panel for questions to Ms. McQuaig. Mr. Baltz. Oh, sorry, Heather. Yeah. Okay, go ahead, Mr. Baltz. Okay, Heather McLean.
Thank you, Mr. Chair. I think you covered one of the questions I had regarding the shared common access. And I think I heard you say that it would say building efficiencies and minimize the built form. And I'm just wondering, I guess this common access is to which units, what floors and which units?
Through you, Mr. Chair, the common access being part 5 will provide access for the additional dwelling units that are located within the front unit, as well as the rear unit. And those additional dwelling units are located in the basement as well as on the second floor. And the reason why I say that this will it addresses building efficiency is that if we were to have the rear unit have its own private access for its own additional dwelling units, we would end up with 2 separate stairwells. And this just did not seem to be the most appropriate way forward. It lacked building efficiency. It would have ended up resulting in a larger built form on the lot. And given that a joint use and maintenance agreement can absolutely cover a shared interior access, I thought this was the most efficient and appropriate way forward to make sure that those additional dwelling units had access. And it also provides for an interior shared space where the additional dwelling units can also have interior garbage room area. So that was part of the reasoning behind this as well.
So there's three units in the front and 3 units in the rear?
That's correct. We were originally only proposing 1 primary with 1 additional dwelling unit, but that was as a result of the timing of the application submission, because the Bill 23 policies around 3 units as of right hadn't been passed by council yet. So we were kind of putting the plan in place so that it could have that 3rd additional dwelling unit once those policies were in place. And fortunately for us, that occurred before this application came before you. And so we wanted to be upfront and say, now that this is permitted, that 3rd additional dwelling unit will be on the 2nd floor.
And the party wall, you're allowed to have a doorway through the party wall then to the rear unit?
That is correct. It would need to be an exterior door. It would have to be a fire rated exterior door.
Okay, all right, thank you.
Thank you, Ms. McLean. Mr. Baltz, you have any questions?
Just a short one through you, Mr. Chair. There's a tree planting plan that's part of this? Or the trees are on the site plan and those will be planted?
We do have proposed trees showing on the site plan. We do not have a tree planting plan prepared by an arborist, but proposed trees are to be located in the rear yard. If it's amenable, we are comfortable with a condition that would specify, what trees and sizes that would be fine.
Thank you.
Mr. Barrett, any questions? Okay, great. Now I'd like to move on to planning. Jerica Gilbert from the city, are you available?
Thank you, Chair. I am.
Do you have any comments with respect to this application?
Not at this time. I'm in agreement with the applicant. It was a tricky one at first, but once we got through the nuances of that shared stairwell, the planning is supportive of this application. Thank you.
Mr. Barrett, do you have any questions for the planning department? We don't. Okay. Ms. McLean?
So I'll just ask city planning. So it's a total of 6 units. It's still deemed to be a long semi-detached.
Through you, Chair. Yes, that was something that at first glance at this application we had concerns with, but after speaking with our policy department, with building code services, so long as there is a party wall between the front unit and the back unit, we're going to be calling it a long semi-detached. I recognize that it doesn't look like a typical long semi-detached that we normally see, but we are living in unprecedented times and they are allowed to have those dwelling units. So yes, that's how building code services would classify it if they came in for a permit today. And that's what we screened it for the zoning bylaw.
Mr. Baltz.
Yes, through you, Mr. Chair. So what differentiates this now from a 6-unit apartment building? It has a common entrance that serves all the units. They all have exterior doors, so that makes it a little bit different, but isn't it functionally a 6-unit apartment building now?
Through you, Chair. It can look very similar, and the main difference at this time through our current zoning bylaw is the ownership structure and that party wall. So it is going to be owned by 2 separate parties, and there is a party wall down the center as per section 138 of the zoning bylaw. Something that I want to speculate, and I believe our policy team is moving towards, and what is happening with the changes brought down by the province is possibly moving forward, we're going to be spending less time on the building typology and more time on the amount of units. So 6 units, while it's a change for this neighborhood, is going to be permitted from here on out for a long semi-detached. So any further questions, happy to answer.
Thank you.
Okay, thank you very much. Now I'd like to ask for some comments from the public. I believe we have one registered speaker. Steve Harrison, I believe you're online or on video. Mr. Harrison, are you available? Mr. Harrison?
Yes, Mr. Chair, can you hear me okay?
Yes, I can. Could you please state your name and your address, please?
Yes, I can. My name is Stephen Harrison. I am at 2215 Boyer Road.
Thank you, sir. Can you please give us a few comments on this application? You have about 5 minutes.
Sure. For full disclosure, I will state that I am one of the properties that is adjoining right beside the 2199 Boyer proposal. But I am speaking on behalf of several of the neighbors that I have spoken to over the last 2 weeks since we found out that the application was going through. So I just thought I'd send in some comments, and we do have some very good, strong concerns, Chair and panel, about this building. As we heard several times already, that this is a very different building for this neighborhood, and especially when we take this long semi-detached and we turn it sideways, it is now going to project completely back to the back of that property quite far. And as I'm hearing now, it is 6 units, not 4 units. So that raises the concern even a little bit more. We are, with 6 units in there, and in the proposal, there's only 2 parking spaces for cars. On Boyer Road itself, there is only parking on one side of the road, and having 2 parking spaces for 6 units, potentially 6 small families, I don't think it's unreasonable that some of these families may have more than 1 car. So that's a huge concern of ours as well. The amount of garbage that would be amassed, the noise and light pollution itself is going to be very different for this neighborhood, and especially the very close neighboring properties, because this is quite a small property. It's only about 30-foot frontage. So although it's very deep, it's very narrow, and it's very concerning to us. On figure 12, I believe it is, of the applicant's proposal, it talks about a property down the road, the only other property that is a multi-unit dwelling. That is an older building. It's not something that is new. It is at a T-type intersection, and it is on a much, much larger lot than is being proposed next door here at 2199. In fact, according to Google, it's twice the frontage. And the building is not long, it is somewhat square, and it does not project to the back of the property, such as the proposal that's going on there right now for 2199. One of the final things I want to point out, it was also compared to the property that is across the street from 2199. That is a vacant lot. That lot has been vacant for a number of years. In my comments that I sent prior to this meeting, I attached an image from 2021 on Google, where you can see the applicant sign for this very meeting and this this very committee meeting. And because nothing has been done, as a matter of fact, bylaw is there all the time because of the overgrowth of bush, I can only assume that that proposal, which also was requiring some changes to the bylaws with setbacks and so on, if I remember correctly, I can only assume that that has not going through as well at this point in time. I haven't heard anything more from that. Finally, just a couple of comments. I think I have another minute or two. You know, snow removal for the property, that property, seeing as the building is taking up such a large space, I'm not sure what they're going to do with that. There is no open lots or areas around this area that they're going to be. So snow is going to have to be removed. That could be a problem. We have a lot of traffic here. As I said, we talked about other properties as well. This is going to bring a lot of traffic, not only from the people who live in the unit, but potentially visitors. And finally, along Boyer Road, heading towards Innes Road, there is a sidewalk that abruptly stops at 2113. It's obvious that it's going to continue all the way up to Innes Road, and that's going to affect, you know, the whole already cramped property and cramped 2199 lot. So we are opposed to this type of building on this property. It is far too intrusive, far too big for this property. It's going to bring way too many people. The traffic, the noise, the pollution, the garbage, all very strong concerns. And that's my comments for now, Chair. Thank you.
Thank you very much, Mr. Harrison. I'd like to ask our panel if they've got any questions for Mr. Harrison. Ms. McLean? No. Okay, Mr. Baltz? Okay, Mr. Barrett? Okay. No further comments from the panel. I'd like to ask Ms. McCaig if you would like to have the final word. Got any further comments you'd like to make?
Thank you, Chair. Just in response to the questions about the use and the size, we did take great care to make sure that we complied with all of the zoning setbacks. We do exceed both front and rear setbacks for the subject property by about 0.5 meter in the rear and 0.15, I believe, in the front. We also adhered to the interior yard setbacks as well. And the use is already permitted. So there are upcoming changes with regards to density and transition within neighborhoods, especially in proximity to arterial roads. And just to the commenter and the resident in the community, to be aware that the city is undertaking a comprehensive new zoning bylaw, and that if they have specific concerns about the future development of their community, now is the time to reach out to city planners and have those conversations. But there is that provincial direction to support housing, especially multi-unit and missing middle housing. And yes, there is an existing multi-unit apartment in the community, but this is, in a way, this is seen as it's the only one there, and we do need that additional variety of housing choice in this neighborhood. So we feel that this is an appropriate location for a multi-unit building of this location, and it does comply with all of the required setbacks and other provisions. So that's sort of what I wanted to comment on. And I believe there was something else that was raised that I did want to respond to, but it slipped my mind at the moment, as I have a little employee coming in to join me for a moment because he's home from school today, which is also why I am virtual today. So apologies for that.
No worries.
But Planner Gilbert, I don't know if you wanted to comment as well on with regards to sort of like the permissions that are in place for this area and how neighbors are going to see a bit of transition coming forward.
Would you like me to respond to that?
Please go ahead.
Thank you.
Gilbert.
Yes, I'm in agreement with the applicant. I'm sympathetic to the neighbors in this circumstance because the neighborhood on Boyer Road is changing. That being said, land use compatibility doesn't mean that we build the same things. And our official plan has identified this area as one where we want it to evolve over time to a more dense urban form. Today, we're not actually looking at what the land use is or what's permitted there. What they are proposing to build is going to be permitted whether the lot is severed or not. we're looking at whether or not that lot can be severed into two halves. And I believe that as according to section 53 of the Planning Act, that it meets all that. So that is my response. Thank you.
Thank you. Okay, now, yes, Mr. Baltz.
So for Ms. McQuaig, I know this is not part of consideration for severance, but just for the members of the public. Can you comment on the snow removal? Maybe that was the one that you forgot that you were going to talk about.
I can comment on that. The configuration of the property right now is such that the driveway is shared and the two parking spaces in the rear will be shared, one for the front primary unit and one for the rear primary unit. It is expected that a snow removal service will be contracted to deal with snow removal, and this will be shared as part of the joint use and maintenance agreement. So that will be one of the items that will be detailed in the JUMA that gets prepared by council legal staff and then reviewed by city legal staff.
And through you, Mr. Chair, snow will be stored on site, correct?
It will be stored on site, probably pushed towards the back in the rear. But if ever the case is needed, I assume it can be trucked away. But that said, there is sufficient space for snow to be stored on this site. The asphalt, area on this site is not all that different than what you would see in a single detached with the double driveway.
Thank you.
Thank you very much. Thanks, Ms. McQuaig. Mr. Barrett, would you like to comment?
Yes, a question to Mr. Quaig. With regards to the parkings, the location of the parking, is there sufficient turnaround radiuses for the cars to be turned around in that backyard?
So through the chair, the cars don't need to turn around. They simply need room to be able to reverse out, and that we did review to make sure that that second space further inward would be able to sort of rear reverse out. And that is it's a more common situation that you would see in interurban areas where you have that reverse out situation for more denser development. And that's sort of what we are achieving here, just so that we can reduce the amount of hardscape and asphalt and maximize our landscaped areas so that we could have trees. But the space maneuverability is there.
Thank you. Okay, so I think the panel would like to reserve on this application. So Ms. McQuaig, we'll let you know in about 10 days our written decision, but we'll have a decision for you at that time. Thank you.
Thank you very much.
Okay. Now we move on to item number 5. This has to do with 335 and 337 Saddleridge. And I'm looking for Lorraine Horsley. Hello.
Hi.
Can you state your name and your address, please, ma'am?
Lorraine Horsley, 335 Saddleridge Drive.
Okay. Can you please give us a brief description of your application today?
Well, I'm applying for severance of the title. Originally, this property that was built in 2010 was purchased by myself and my husband. He owned 337 and I owned 335. And then he passed away in 2014 and I inherited his side and did the due diligence with the lawyers and such. Unbeknownst to me, I had never been informed, the titles merged. And my new partner here and I became co-owners of 335 about 3 years ago. And the title was registered and such by the lawyer. And we thought everything was fine. And then just last month, I put 337 up for sale. And we have a purchaser. And when they went to register the title, the purchaser's lawyer discovered that it couldn't be registered because the titles were merged. So here we are. I'm applying to sever for that reason, and also to straighten out our ownership, my partner and I, on a 335.
Okay, thank you very much. Now I'd like to ask Ms. McLean if you've got any questions for the applicant. Okay. Mr. Barrett, do you have any questions for the applicant? No. Mr. Baltz? I note that there's probably a need for us to put into the record the change in or update the status of the description of the property. And it should read, I believe, and I think Jerica Gilbert can confirm this, block 153, plan 4M-1370, further described as part 1 to 3, plan 4R-24181. Is that correct?
Yes, Chair, it is.
Okay, so we had to update the legal description of the property.
Okay.
Okay, so that's done. I'd like to ask Jerica Gilbert for any comments she has.
Thank you, Chair. I don't have any for this one.
Okay, Ms. McLean, any questions for Jerica Gilbert?
Thank you, Mr. Chair. Just to city planning staff, there is no request for independent services or a joint use on this property. Is that because it's a recently constructed?
Through you, Chair. Yes, so the story behind this one is it was originally built by Claridge Homes in 2010 and divided through part lot control. So they already have separate servicing. So there's no need for new installation or anything like that. Thank you.
And the joint use, I guess, is there's no need for a joint use agreement, or?
Not in this circumstance because they're side by side. They're not along semi. They'll be completely separate down that property line.
Okay, thank you.
Mr. Baltz, do you have any questions for Planner Gilbert? And Mr. Barrett, do you have any questions for Planner Gilbert? No, no questions. Okay, great. Lastly, I'd like to ask the applicant if you've got any questions or comments.
Well, I was informed that there would be 2 conditions that would be required to be met.
Yep, there are actually 4, but 2 of them are standard. The first one is proof that the party wall meets Ontario Building Code.
Right.
And the second is a tree planting plan.
Right.
The third and fourth are just our normal committee of adjustment ones. You register your reference plan confirming frontage lot area of the severed lands. And the fourth one is electronic registration in preparation documents for certificate for official.
Okay, well, I don't know what that is, but I'll figure it out.
Okay, I'm sure Planner Gilbert can give you a hand with that.
Okay,
to give you some direction on where that is.
Okay.
Okay. Okay, so I would like to ask the panel to reserve this application. Yeah, and to that end, all those in favor? Reserve it, or would you like to make a decision today? Would you like to make a decision today? Would you like to make a decision today?
Should we inquire of the? Sorry, I'm not on. Should we inquire of Planner Gilbert whether the party wall fire meeting the fire code is really an appropriate condition, given that this is all right. So I will, may I do this? Yeah. So to you, Planner Gilbert, this is an existing building that isn't changing in any way. So I'm wondering why, when all the other presumably Claridge built buildings of the same exact type in this subdivision don't have to do this, why this becomes a condition just to reestablish ownership. Is it really necessary?
Through you, Chair. I know it seems a bit excessive, but there have been circumstances in the past, however unlikely in this case, where the party wall isn't fireproof to a certain standard. I do have an email from Building Code Services that says that the permit on file for this property denotes as townhouse. So while it's more than likely that the firewall goes all the way up, there is another type of building method that they could have used at that time. So I would suggest that that condition is left in over just abundance of caution, just so Building Code Services can ensure that there is fire separation between units, since that is pretty important. I should also make a note. I'm just receiving word from my colleagues. Your question about Adjournment I may have missed that initially. May I ask the applicant if there is a Adjournment on title for the?
Absolutely, go right ahead, Planner Gilbert.
So when we talk about Adjournment, we're talking about a joint use and maintenance agreement. More than likely, there should have been one put on title before. Do you know if that's in existence?
What is a joint use and maintenance?
So it would just ensure that that common party wall between the units, that the future owners of each half would be able to maintain it.
Yeah, there is a joint use and maintenance, what do you call it?
Agreement?
Hmm?
Agreement?
Yes, there is. Yeah, there is.
Right, and
I saw it in my legal papers.
We might want to double check that before it's up to the committee. I just wanted, since my colleagues flagged it and committee member McLean mentioned it. So.
Right. So can we add another condition, just that we receive a copy of that joint use and management agreement and put that as an additional condition to this consent application?
Okay.
Okay, so we're going to add that other condition to this. Now, Mr. Balls just brought up this great point. I'm having a real struggle with number one as well. Proof of that party wall meets Ontario Building Code.
What?
Man, so it was built to code at the time. It was inspected by city inspectors and passed. The builder received an occupancy permit that allowed both parties to occupy their premises. Why do we need to have a further condition just reproving all that over again?
I am not an expert in the building code. Based on what the staff member has told me, and unfortunately they're not online for us to really inquire, this was listed as a townhouse, which is different probably under the Building Code Services over what we do in zoning. It could be the case that the firewall, it could have passed code without necessarily having that firewall go up the whole entire line. I think it's very unlikely in this scenario, but mistakes do happen down the line. So if our staff believe after reviewing the file that it should be something that we should check, I'm in agreement, because that's essentially what that condition is just that they either have an inspector go out or the applicant submits photos, just ensuring that was done. Is it likely that it was done? I believe so, but there's always that small chance, and I just don't like to leave that type of thing up to chance. So that's my 2 cents.
Is it okay? Can we leave this condition in? Are you satisfied with it? I'm getting a little frustrated by its severity.
Well, I am too, because, well, first of all, it's a bungalow, and there are several bungalows in a row on our street that were all built by Claridge and semi-detached and sold, and they all would have been, approved, the permits and the inspections and such.
337 was inspected.
Yeah, and actually we just sold 337 next door. I did, and they had certified inspector inspect it as one of the conditions of the sale, and nothing was ever mentioned that it passed the inspection fully. I don't know if that's of any significance or not.
That's fine. It's good information. It's very
Yeah.
good information.
Yeah.
So I'd like to propose that we reserve on this application. And you'll get your answer. We'll make a decision today, but it'll be given to you in a written decision within 10 days.
Okay.
Okay.
Mr. Chair, if I could just interrupt, I'm looking at the parcel register and there is a Juma registered from 2010 on title for both these properties.
Okay, thank you. That's great information as well. Again, we're going to be reserving this this application, and a decision will be provided within 10 days.
So what does that mean, this last part?
So it means that there's already the joint use management agreement that is on title according to
Oh, good.
Our coordinator.
So I don't have to provide that.
Well, again, you'll receive a written decision, and that written decision will have the conditions that you need to fulfill in the next 2 years. Okay.
Good.
Mr. Chair, given that we're reserving, can I ask the one last question on this tree planting plan, which is a condition? Is that, why is, again, it's the same type of question, and this is just the severance. Why are we looking? And I'm very pro tree, as you can intuit from the rest of the hearing, but it seems a little excessive when they're re-severing something that just merged on title.
Yes, through you, Chair. It's so this one didn't require a tree conservation report or anything of that nature. The tree planting plan is just to add to the urban tree canopy, which we like to do whenever we have the opportunity as the city to do so. And Lorraine has spoke with our forester, Nancy Young, and to my understanding, there's an agreement there already. So that condition will be cleared very, very quickly.
I've already applied to the city for the free tree planting, and my application is in. They've already come by this morning and they've marked the, the
location of
the
where
locations.
So through
and
you, Mr.
such.
Chair, you're fine with that condition?
So it's fine.
Okay, thank you.
So that, I think, concludes our business for today. Thank you, everybody, for your help. And we'll see you in about a month now, December 12th. Thank you.